This is Speak Up. Welcome back to our show. I'm so delighted to be back here to talk to you about something very, very important. Please get your pencil and paper or pen and paper because we're going to talk about something that's so important to the tenants and shareholders of our city and state. People have been asking me about the Housing Stability and Tenant Protection Act. This is an act that the landlords and the managing agents and the lawyers that represent the managing agents and the Council of Co-ops and Condominiums and the Cooperator magazine are working hard to get repealed and get watered down. So if they're trying to get it repealed and watered down is to protect tenants, that means you have to work to protect yourselves. We will start by talking about overcharges. What happens? What is the remedy available for overcharges of rent under this act? Who is lodged with bringing an action against the landlord? A complaint may be filed with the New York State Division of Housing and Community Renewal. I repeat that place, New York State Division of Housing and Community Renewal. That's where you bring the charge of overcharging for rent. Where does the proceeding take place? The New York State Division of Housing and Community Renewal shall apportion the owner's liability between two or more tenants, not one, two or more, found to have been overcharged by such owner during their particular tenancy of a unit. How far back can the tenant claim rent overcharging? They can go back 6 years. 6 years. Is there any restraint on the landlords taking over multiple apartments, presumably for his or her family's use? A landlord is only entitled to one apartment, not more. If they're overcharged, there should be a penalty of 3 times the overcharges which were collected from the tenant. Any affected tenant should be notified in writing of and given an opportunity to join in any complaint filed by an officer or employee of the State Division of Housing and Community Renewal. An owner found to have overcharged shall in all cases be assessed the reasonable costs, attorney fees of the proceeding, and interest for the date of the overcharge by a rate of interest payable on a judgment pursuant to Section 5004 of the Civil Practice Law and Rules. Remember, the look back can go back 6 years. So if they've overcharged you for 6 years, you have a claim. Can a tenant still be blacklisted from becoming a tenant because he filed a complaint against a landlord in a court? Well, I call this a regulation of good intentions, because how can you tell that the potential landlord looked on the computer, and it's available on the computer, to see if you filed a complaint in the court against any landlord? Now, what happens if a landlord does not want to extend a lease for more than 2 years? Well, he must give a 90-day notice of the fact that he does not want to do that. What is the procedure that must be followed to prove late payment of rent? The landlord must give written notice of late payments. Now, this might be, of course, on his demand for rent. This law does not state that the landlord must publish what constitutes late payment. This can allow discrimination between tenants, because he may assume that, or claim that, or not charge a tenant late fees when he paid after 15 days, but charge another tenant late fees when he did not pay after 5 days when the rent was due. And the question is, when is the rent due? Well, the regulation does not state that the landlord must prove when he sent out the bill, or that when the tenant received the bill. It does not state the time allowed between the receipt of the bill and the receipt of payment. It does not state that the date the payment was posted must be stated, as late posting could be used to give the impression that the payment was improperly made and therefore late. What happens if the tenant does not uphold his end of the warranty of habitability? The landlord must provide a cure path for tenants to fix issues. To me, this means the landlords must tell the tenant in writing what is needed to satisfy the landlord concerning the part of the lease that the tenant must uphold concerning warrant of habitability. What happens if the landlord has to fix something that is the responsibility of the tenant? The landlord has the right to reduce the security deposit in full or in part if the landlord fixes the issues. Can the landlord evict a tenant because the tenant filed complaints like heat complaints or complaints about the condition of his apartment due to the water damage coming in with the city? No, that he cannot. The warrant of habitability in a lease also includes a duty to repair. It precludes retaliatory eviction due to complaints about the housing condition. What time is a time frame prohibiting retaliatory eviction? It's 1 year. The question is, can he evict after that 1 year for a complaint filed by the tenant? Fees. Can a landlord evict because the tenant has not paid legal fees in a summary proceeding? Fees are limited only to what can be sought in a summary proceeding, except if it is provided by statute or regulation, Section 745 of Real Property Acts and Proceedings. Can a tenant withhold his rent if the landlord is not curing conditions affecting the habitability of the apartment? According to Real Estate Action Procedure Law 745, the tenant may put his arrears into escrow. Now, a motion at this time, since the new law, is that a motion must be made to have the tenant put the money into escrow. If the tenant makes allegations about conditions to justify his non-payment or occupancy. So, if the tenant has made allegations about conditions to justify his non-payment or occupancy, he has a right to put his rent into escrow. When must a tenant pay? In order to pay his good only on the date of the order and only on written notice. However, if the money is not paid, then there is a trial. There is no claim of rent possible if there's a proven claim of overcharge or hazardous condition. According to Real Property Actions and Proceedings 753, the landlord has liability up to $10,000 for this violation, and he cannot evict on ancillary charges. When will the court give the tenant 1 year to pay? The court gives 1 year to pay or be dispossessed only when there is extreme hardship for the tenant, according to Real Property Actions and Proceedings 753. Now we're going to talk about co-ops and condominiums. Can a tenant be evicted if he does not purchase his or her apartment? No longer will there be allowed eviction plans under conversions. Now there's an important definition that's given in this act. A co-op is a landlord. A person who applies to live there in a co-op is a tenant. How many tenants must buy for a building to be converted to a co-op or condominium? For a conversion plan to happen, 51% of the tenants must buy. Not 49%, 51%. That's very important because otherwise the landlord still has control of the building if it's 49% or less. Can one buy after the building has become a co-op, a condo? One has the right to purchase up to 90 days after closing with a 60-month extension. But again, there is not allowed an eviction plan. You can still remain as a renter. In a co-op, a person has 17 days to respond to a non-payment proceeding. Are there any restrictions on increasing the rent due from a tenant after capital improvements, major capital improvements? The rent cannot be increased. The landlord can only spend $15,000 on capital improvements in an apartment over 15 years. Are there any restrictions on eviction proceedings based on retaliation? No landlord shall save a notice to quit upon any tenant or commence any action to recover real property in retaliation for a good faith complaint by or on behalf of the tenant to the landlord's agent or government authority of the landlord's alleged violation of any health or safety law, code, or ordinance under the warrant of habitability under Section 235. The landlord has a duty to repair under the laws of New York State, which regulates dwelling places. The reason this has been put into this bill is that too often, when a tenant complains, a landlord tries to throw the tenant out. How is a claim of retaliation established? Oh, before I talk about that, another reason for retaliation many times is that the tenant has participated in a tenant organization. Now, no landlord or a landlord's agent can substantially alter the terms of the tenancy for any action set forth in the above, namely a good faith complaint or the tenant's participation in a tenant organization. Do hindrances on evictions apply to all residential buildings? Yes, they do. In any proceeding to recover an apartment, judgment shall be entered in favor of the tenant if the court finds the landlord is acting in retaliation for an action set forth as stated before. The tenant still must continue to pay his rent.
Can we pause for 1 second?
Sure.
Where are we in the script?
25, question 25, page 2.
How many questions are there?
A lot.
Okay.
I'm tripping over my tongue. You know, this is boring as hell, I'm afraid.
Shock here. I'm cutting off your hand, so we'll go inside it. At least for this camera.
It's all right.
All right. Now, you could always look at the camera 1. You could always look at the camera 2. But make one decision. Don't look in both when you're doing a question. Okay, so if you're going to do one or the other, just stick to one camera
All
every
right.
time you look up.
Okay.
Right? That's 1. Number 2. What was your late husband's name?
David.
David. Now, David doesn't know anything. David is here. David wants to come back to visit you, and maybe David, your beloved, is looking to lease an apartment. He has all these questions about renting and laws regarding whatever, right?
Yes.
So let's say, actually, where did you and David meet?
Where did we meet? We met, well, we sighted each other on a bus. We met that's kind of a convoluted question. I found something that belonged to him and I tried to return
I
it.
love that. Okay. Now you found something of his, you returned it. How do you remember how you felt?
Well, how I feel? I felt like I really should give this back to this person, get this.
No, I mean when you met him.
I was surprised because I had seen him before.
Oh, okay. Sometimes that's just the way the universe works.
It's like with you, with your the person you're with.
Yeah.
It was similar, at a similar occasion.
Yeah.
I had seen my husband on the bus.
Yeah.
He had seen me on the bus.
Yeah.
We hadn't talked.
Yeah, he saw me on TV years ago, before we even met.
Mm-hmm.
So, my question to you is, whether it could be David or it could be a friend, David is going to be like, look, let's say you're looking into David's eyes.
Yes.
And you want to explain this to him.
Oh, God.
Right. It's okay. However you would. Take your time. If you need a sip. You're like, look, no, you don't have to do that. The law says it. I know, I wrote it. It's right here. I researched it. Right? Be a little more. You're not in the studio right now. You're talking to whoever's on this other side of the table. It's a camera 1. This is your dining room now. Right? Your dining room, this is how you dress up every day.
Sure.
Because sometimes we do feel like that.
Right.
Sometimes we don't want to put on our nice jacket and blow out our hair, and that's okay. And for David, why not? Mm-hmm. He's coming to visit you. Maybe this is his first time in your house. He has all these questions. Of course, he's not really interested in this. But you're going to explain it to him because you like him. You know he likes you, and you know this is not really why he's here. He's really getting to know you. But he's impressed with what you know about this stuff. So why don't you...
Relax.
Not just relax, but how would you tell a friend? How would you tell David? How would you sell it to him?
Oh, dear, dear.
Is that okay? Have you went there? Right. That's okay. However it makes you feel. Let's try it.
Oh, God.
Yeah? Do you need my pen? Where are we?
I don't know. That's where are we? The website. When's interested? How was retaliation established? Here we are. How was claim of retaliation established?
Okay, do you want to start?
Here, right here.
Okay. All right. I'll now count you in, okay?
All right.
Uh-oh. Did I move? Did you move?
I have no idea.
You look great. Okay, my lovely. In 5, 4, 3.
Now, how is a claim of retaliation established? Well, many times a landlord will make a laundry list of complaints about you. But this law says that he has to have a preponderance of evidence. In other words, he has to have real evidence that what he's claiming actually happened. He can't just take a little snippet here and say, this is what happened. He has to really prove it. Now, and I hope that this gives a tenant the right to poke holes in what he says. I hope that, because I've seen instances in a courtroom where a judge will simply take these allegations as whole evidence without hearing from the other side. When is a landlord's claim for attorney fees void? Any lease provision that seeks to assess a fee, like lawyer's fee, in addition to the stated rent against the landlord, because a tenant filed a bona fide complaint about the conditions in the apartment, hazardous conditions, against a landlord or with a code officer regarding his premises, those attorney fees will be null and void. But a landlord who seeks to enforce such a fee will be liable for triple the amount of such a fee. That's the deterrent. Of course, you have to bring a proceeding about that. How does a landlord establish that his eviction proceeding is not retaliatory? He has to bring an overwhelming preponderance of evidence to prove that it's not retaliatory, not just allegations. Namely, not just a laundry list of allegations. The court will give the tenant a year, especially if the landlord has a... No, we've done that already. A landlord may not recover attorney fees in a default judgment. Now, what is a default judgment? It's something that a court orders. It's not something to have to do with rent or tenancy. It's something the court orders, and that's when a landlord is not entitled to attorney fees. When must a landlord issue a written receipt for payment of rent? And what must be in the receipt? A lessee may request in writing that the lessor provide a receipt for rent paid by personal check, cash, or other instrument. The receipt shall enumerate upon payment of the rent the following things: the date, the amount received, the identity of where the apartment is, the period for which paid, the signature and title of the person receiving the rent. However, there are many times when the landlord will not let the tenant come to his office to pay in person. That's another problem. However, if the payment is personally transmitted to a lessor or person authorized to receive the rent, the receipt shall be issued immediately to a lessee. If the payment is made indirectly to a lessor or an agent of the lessor authorized to receive the rent, like a managing agent, a lessee may be provided a receipt within 15 days of such receipt of the rent payment. But again, the problem is many times the landlord will not let a tenant or someone acting for him deliver the rent. And he may sometimes say that he didn't receive the rent by mail or whatever. So I suggest sending it by certified mail. And then, of course, he may say still that there was something that the rent was not in the envelope. So that's why this law needs to be amended so that the tenant can actually hand deliver the rent to the landlord or his representative. When can a landlord charge fees? When can a landlord charge late fees, and how much can he or she charge? Except where the law requires payment, fee, or charges, no landlord may demand any payment for the processing of an application to rent, except he can charge for background checks or credit checks. However, the landlord may not charge more than $20 as a fee associated with a background check or credit check. And this fee can be waived if the potential tenant provides a background or credit check made within within the last 30 days. When asking for the $20, the landlord must present the receipt for his payment and a copy of the background check to the potential tenant. No landlord may demand any charge for late payment of rent unless it has not been made within 5 days after when it was due. The question is, when is it due? The landlord has to have some kind of late payment description of when a rent is due. That's an open question. However, such fee may not exceed $50 or 5% of the monthly rent, whichever is less. And no agreement can be made altering this. Not in settlement, not anything else. Not even an original rental agreement. Now, what constitutes rent? Under Section 705. Rent is the monthly or weekly pay amount charged in